Hi guys, welcome back to Courtroom Clapbacks. Today we are headed to Wyandotte, Michigan, into Judge Elizabeth DeSanto's courtroom, where she is rebuking a dad for laughing during his arraignment for child abuse, child torture, child neglect, and failing to report his missing children. It's a disturbing case, so drop your comments below and let me know what you think. I'll let you guys know what I'm thinking after the video. But for now, grab your popcorn and let's head in because court is now in session.
On the record in the matter of the state of Michigan versus Eric Bell, 26667.
Your Honor, Your Honor, John Goldthorpe, P. On behalf of Mr. Bell.
Thank you, Mr. Bell. Your name for the record.
Eric Bell.
All right.
And Your Honor.
Counsel, as to the arraignment.
And charges waived or when he got those charges, asked the plea of not guilty.
The court's going to waive the formal reading. Sir, you do have the right to have an attorney represent you. If you're unable to afford an attorney, you may request to have one appointed to represent you. And you did, in fact, have an opportunity to speak to an attorney today. Is that correct?
Yes.
The court is signing the petition order for appointing an attorney for felony matters. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, I do.
The court is entering a plea of not guilty on your behalf, scheduling this matter for probable cause conference, May 28th at 10:45 a.m. is what I believe that's set for already, I think. Stacy said she already had the time in there, I think. Does 10:45 work for us?
It does.
Okay. I may have just made that time up, but I'm pretty sure that's what she said. Okay. And counsel, as to bond.
As to bond, Mr. Bell is 53 years old. He did have a prior CCW in 1996. He's not on probation, he's not on parole, and he's never failed to appear in any previous matters. As I indicated, he's 53 years old, he's married, he has 5 minor children. It's my understanding that those minor children are no longer living at this time in the marital home, and he's gainfully employed. He works at, we believe it's the Hungry House. Your Honor, these are very serious allegations. I've had an opportunity to speak with Mr. Bell, and he does understand the purposes of these proceedings. I believe that particularly in light of it's my understanding that there was, and because of his lack of any prior criminal activity since 1996, that upon commensurate with the charges, but also with the understanding that he is innocent until proven guilty, which I know the court looks into, should be addressed as well. This incident, the complaint was just signed yesterday, and there's been an ongoing investigation since October of 25. We're asking for a reasonable bond under the circumstances, and one which both Mr. Bell and we'll be addressing this co-defendant shortly, can make under these circumstances so they can prepare to defend.
Mr. Bell, how long have you worked at Hungry Howie's?
6 years, Your Honor. I do believe it'll be 7 this June 22nd.
If you're to test right now, sir, what is in your system?
I'm sorry, I could not hear you.
If you were to test right now, what is in your system?
Marijuana only.
Do you have a valid prescription for that, sir?
No, ma'am, I do not.
Have you ever failed to appear in court for any reason, sir?
No,
Are you on probation or parole anywhere?
no,
Ever failed to appear in court for any reason?
no.
Detective, would you like to address bond?
Yes, Your Honor.
I'm sorry, your name for the record, please.
Detective Chelsea Happy.
Thank you.
Your Honor, the allegations are very serious and violent in nature. The juvenile victims are still part of the community and reside within this community, neighboring communities. I have serious concerns for the safety and well-being of the children. And based on the allegations and some statements made, I do have concerns that Mr. and Mrs. Bell will not return back to court or have thought about possibly fleeing the area. They have loose ties to this community other than the job that Mr. Bell works. So I'm gonna request a $250,000 cash bond.
The court has reviewed in this matter, obviously not in as much detail as the detective has, the nature, the allegations and the nature of those allegations. Your client has 5 pending charges for child abuse in the 2nd degree. Based upon what this court heard yesterday, when this court listened to information from Detective Haskin prior to this court signing the warrants, the court has significant concerns for the safety of these children. Given some of the allegations that were placed on the record yesterday, the court has concerns that Mr. Bell will not return to court and will flee the state. The court also has significant concerns based upon some of the allegations that there would be attempts to contact the victims in this matter. Therefore, for those reasons, this court, given the nature of these charges and the significant seriousness of these charges and the violence that's been alleged against these children, this court's going to remand Mr. Bell without bond.
Your Honor, I wasn't present. You don't know what the other allegations are, which were not in the reports that I reviewed.
And counsel, what I will do for the record is there are allegations that your client would, if there were pending charges, would flee the state. There are allegations that that when CPS reports had been made, there were great efforts made to stage a home that would not suggest that children were abused or neglected. And then when those the CPS worker would leave, then the items that were staged would be returned. Those are the allegations. So based upon all that, the court has significant concerns. Let me be very clear, Mr. Bell. You may be smiling, you may be laughing, you may be thinking that this is ridiculous. I don't know. But let me just say this, sir. While you are in custody, you are not allowed to contact any of your children. None. Zero. Zero.
Okay,
The court will also note, counsel, that it's based upon what this court reviewed yesterday, that the children, that there's children that have not been at the home, nor have they been reported missing. And they've not been at the home for over a month, and neither one of the parents reported these children is missing or otherwise. The court will also note, in addition to your children, you're not to have any contact with Shannon McKinney or Nancy Fivila or anybody else where your children may be staying with for safety or otherwise. You're not to return to the home at 11th Street, but you can't because you're not going to be allowed to be released from custody.
Thank you.
Excuse me?
My bad, that's protected. Please. Thank you, Your Honor.
Who is this?
It's Mr. El Sandu, Your Honor.
Sir, you have no relation to this court case. Please stop speaking out in court. No outbursts, please. Any questions? Any questions, Mr. Bell?
I do have a couple. I'm trying to think of which one to ask first, Your Honor. I'm not laughing or anything like that. I know this is extremely serious. I don't even know what I wanted to ask you, Your Honor. I'm so dumbfounded by these charges.
Okay, so then, you know what, sir?
Okay, about the charges.
Then what I'll do is I will give your attorney an opportunity to meet with you again, and you can ask your attorney any questions that you may have.
Okay.
See you
When
back on May
said no-
28th. What's that?
You said no contact with any of my children until after the 28th or whatever. Does that include the older children that are over 18 as well? Because I do have my oldest son that does come and see me every now and again.
Sir,
Yes,
I'm
ma'am.
pretty certain I was clear. No contact with any of your children. Any.
Okay,
I didn't say whether they had to be below 18 or not. Zero contact with all of your children. Not one person, not one of your children are you allowed to have contact with.
okay. I just wanted to make sure in case he drops by, I can tell him to go away. No, not a problem.
Well, I'm not sure if he would be dropping by the jail, but you won't be home for him to drop by.
Right. I thought you meant after the fact of the 28th.
All right. Have a good day. We're on the record in the matter of the state of Michigan versus Danielle Bell, 26666.
On behalf of Danielle Bell, Your Honor, this is the co-defendant with respect to Mr. Eric Bell. I addressed the issue of conflict. I've indicated that I will be representing Miss Danielle Bell only for the purposes of this arraignment. She understood that I would also be doing the same for Mr. Eric Bell. And as such, Your Honor, she has agreed that there would be no conflict for this limited purpose.
Thank you. Ms. Bell, I'm so sorry. Ms. Bell, your name for the record, please.
Danielle Yvette Bell.
Okay.
And as for the arraignment, she'd stand mute to the charge, where before we none of those charges, ask the plea of not guilty be entered on her again.
The court will waive the formal reading. Ma'am, you do have the right to have an attorney. If you're unable to afford an attorney, you may ask for one to be appointed to represent you. And you have had the opportunity to meet with an attorney today, correct?
Yes, ma'am.
The court is also signing the petition in order for appointing an attorney for felony matters as well. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes, ma'am.
The court is entering the plea of not guilty for purposes of the arraignment. Schedule this matter for probable cause conference May 28th. And counsel, as to bond.
Your Honor, Mr. Bell is 49 years old. He's been married for 28 years to the co-defendant, Mr. Eric Bell. She has never had any contact with the criminal justice system. This is her first time even seeing or being charged with anything. She's not on probation. She's not on parole. I've indicated she's never had any prior contact and hence also has never failed to appear when requested. She is unemployed at this time. She's been a stay-at-home mom, for lack of a better term. Your Honor, we're asking for a bond. Again, these are very serious charges. There are the identical charges rendered against the co-defendant in this particular matter. And I feel that in her case, particularly, of having no prior contact whatsoever, that a bond commensurate with the charges would be appropriate, but I do not believe that remand is required, nor do I think that a $250,000 cash bond will be appropriate under these circumstances. Asking for a bond which was more in tune, again, without getting into the separation of responsibilities, that would be someone down the road, asking for such a bond. And I would suggest that 25,000, 10%, well, I'm sorry, something in the area of a 10% bond, which can hopefully be paid, but not 250,000, 10%.
All right, and so, ma'am, have you ever worked outside the home?
Not in the last 30 years.
And how long have you resided at this home, ma'am?
15 years.
Do you have any pending charges, ma'am? Other than this matter? Do
I could hear that, I'm sorry.
you have any other matters that you have pending other than this court?
No,
And you've never had a driver's license?
no,
Where did you reside prior to the home on 11th Street?
we lived on Pickwick Circle in Taylor.
Detective, would you like to address bond?
Yes, Your Honor. Similarly for co-defendant, due to the seriousness of the allegations, the violence of the allegations, was serious concern for her minor children as well as her adult children, who are the complainants in this case. I would ask for a $250,000 cash bond. Ms. Bell has even less connections to this community. She does not have family or friends or a job. And as stated previously, there was some information that they could possibly flee the state and not show up to court. So that is my recommendation.
And Your Honor, if I may, I don't know what else more. She's at less community. Contact with this community. She resided in this community for 15 years. So there is considerable contact and in this community. I just want to point that out. She has no prior criminal record whatsoever, doesn't even have a driver's license, so I don't see, and the lack of employment outside of the home does not render her community and presence in the community any less. I feel that the 250,000 cash bond is quite excessive under the circumstances with respect to this step back.
Detective, is CPS involved?
Yes, ma'am.
And what is CPS's involvement at this point?
CPS is currently working to give temporary, housing to the one child that was still in the home. And they are also putting in a request for removal of the parental rights of both, the Bells to the Attorney General's office.
Counsel, the nature of the charges are incredulous and reprehensible.
I don't disagree with
And the allegations aren't any less for Miss Bell than they are for Mr. Bell. Based upon the seriousness of these charges, the concern that this court has for the victims, the children in this matter, the allegations of the physical violence and torture these children have had to undergo, in addition to not being permitted to attend schools as alleged, putting on a front for CPS when there have been CPS workers at the home that's been alleged. The court has the same concerns for the safety of the children as it relates to Miss Bell as the court had for Mr. Bell. As such, the court's going to remand Miss Bell to court or to custody as well. Ma'am, you are not to have any contact with any of your children. Zero. It's phone contact, text message, email, social media, third party, anything of the like. Not at all. Nor with Miss McKinney or Miss Fee Vila.
Thank you, Ron.
Thank you, Your Honor.
Thank you. Have a good day.
Well, that was a disturbing hearing, wasn't it? And we haven't even heard the trial yet. There's no telling what the details of this case is going to be. But the fact that DHS is already moving to sever the parental rights of these two, even before their trial or possible guilty pleas if they don't go to trial, it lets you know that they probably feel they have plenty of proof of the allegations to request that their parental rights be severed. So I watch a lot of court cases, but if you're like me, the ones where the victims are children are the hardest ones to watch. And they're just, I don't know, they're just so hard to think that these are just the cases where the evidence comes out, but you think of all the little children that we can see every day that are going through situations in their families that we don't know about. It's just so heartbreaking to see how rampant this is. The more cases that you watch, it's just horrible. But it didn't seem like this dad was taking this arraignment too seriously. What do you guys think? When Judge DeSantos was like, go ahead and laugh, or you might laugh. But maybe when Judge DeSanto decided that to go along with the prosecutors, actually to go beyond what the prosecutors were suggesting, they wanted the cash bond, a cash bond, not 10%, but a cash bond of $250,000 before there could be any bail. But instead, Judge DeSantos said, nope, he's going to be held without bond, and so is his wife. What do you guys think about that? Should a defendant who is supposed to be presumed innocent until proven guilty be held without any bond at all before trial? What do you think? I say yes. There are some cases so egregious, and Judge DeSantos seemed to, when she was talking about how disturbing these details were, it just sickens you to hear. And also, this guy works at a pizza place. How easy is it going to be for him to pull up and take off before this case heads into court, to flee the state? Okay, it's disturbing just to think about. So drop your comments. Let me know what you guys think. This guy needs to watch his back in jail. Just even the details of it being with the hearing going on. This stuff gets around in jail. And he has to watch his back in jail. And indefinitely if he goes to prison, because prisoners have their own their own code of justice. So let me know what you guys think. And if you like videos like this, if you want me to keep looking for these videos and posting them for you, then like and subscribe and let the algorithm, let YouTube know that this channel is worth promoting. But until next time, when we meet here again for another video, court is now adjourned.